everybody listening right now, you should go check your policy. When I learned from insurance companies themselves that 67% of short-term rental investors do not have commercial coverage and they don't know it, you need to make sure you have the right type of insurance and that you're properly not underinsured. You need to make sure you've got enough of that insurance. That's the big thing right now. Even if people think they don't need LLCs, they don't need asset protection, you cannot just be sitting out there bare with no strong commercial insurance, because otherwise it's not a matter of if, it's a matter of when someone's going to get hurt on your property.
Welcome back, everyone, to the show. We have Jeff Hampton at STR Law Guys. Jeff and I have been working together forever on STR compliance, LLCs, asset protection for short-term rental investors. Jeff, how are you doing today?
Doing great, man. Thanks for having the time to bring me on here.
So, Jeff, how long have you been working specifically with real estate investors on asset protection?
So I've been working doing LLCs, some form of asset protection for probably about 10 years, but specifically with short-term rental investors really since around 2020, 2021. And that's mainly because I became a short-term rental investor myself, right? So once I started investing in my own short-term rentals, I think I mentioned this to you before, but we've talked so much about this. I used to sue short-term rental owners. And so as part of my personal injury law firm, and that just kind of gave me a greater appreciation to say, okay, let's try to provide the knowledge about what it really takes to protect yourself to the short-term rental industry and the rest of the rental, basically the real estate industry. And let's get this information out there. So that's kind of what led me to talking more about it in the marketplace.
So you were able to pick apart a bunch of other short-term rental hosts or like lawsuits and vacation rentals, and you figured out which structures were unbeatable, essentially?
Well, I mean, so essentially what happened is it's pretty low-hanging fruit when you sue short-term rental owners, because a lot of times what happens is, the very savvy real estate investors that I had sued, they knew about holding companies. They understood about ways to not only remain private, but also make it to where I couldn't force them to sell, even if I won the lawsuit. But I mean, not only are most short-term rental investors, they're not properly insured, but secondly, most of them they have so many common misconceptions about understanding LLCs that it made it pretty easy to sue short-term rental owners. And what's sad is it can be ruinous. I mean, you don't ever want to invest in another short-term rental again if you lose your rental or if you lose personal property or personal assets because someone got hurt. I went that direction because it was easy pickings. I mean, a premises liability lawsuit against someone who doesn't understand how to protect themselves made it a quick, easy settlement for my client.
And what are some of those common, I guess most people get the first couple of properties, but what are some of those common misconceptions you see a lot?
Well, one of the biggest ones, and I see this sometimes even with more, investors that have several properties, is that they think they can put multiple properties in one LLC. And so they'll turn around and they'll say, hey, why does it matter? I have an LLC. I'm just going to put 3 properties into one. And I always remind people, that business, that entity structure now owns all 3 properties. So if I want to sue you, if I was going to sue you, and all 3 properties would be frozen now if I sued your LLC, and you could potentially lose all of them in a bad lawsuit. That's one. The second one, another big one that comes up is people think that all LLCs are created equal. They'll just say, well, an LLC in any state protects me no matter what it is. And they don't have an understanding that every state law is different. I mean, they know that it's different, but they don't understand how drastically different. There are truly only a handful of states in the country where if you set up an LLC, transfer the title of that property into that LLC, where you actually have the 3 things you want. I love for my clients to have privacy as much as possible, so lawyers can't do asset searches and try to sue you. You want what's called charging order protection, meaning that even if I sue your property in an LLC and I win, I can't force you to sell, which kind of disincentivizes the lawyer from wanting to sue you. They'll go to your insurance. And then thirdly, I like to have some single member LLC protection, and very few states offer all 3 of those as part of their law. And so when people say, like in New York and California, they have no idea how terrible their laws are and how poor the courts are going to interpret it for a property owner. And they're going to be so very plaintiffs friendly. And then finally, another third one, I could go through a list of many of these things, but another one is that people don't understand holding companies. A lot of local asset protection attorneys or local business lawyers don't really know the laws in other states. So a lot of people will, and it's shocking to me how many times I've seen this, they'll get a Florida property and then they'll set up like a Florida LLC as a holding company. So they already have a Florida LLC holding their property, but then they set up a Florida LLC as their holding company, and they think they're now more protected. In reality, if I can sue through one of your LLCs in one state and you don't get a better state as a holding company, I'm going to sue through the next one too. So that's where you have to become aware that you cannot, and the best example I'm going to give you this without getting too long-winded on this. If you have a property in Florida, you can't just go set up a Wyoming LLC and dump the Florida property into it. If you do that, you're not getting Wyoming's protection because it's Florida law, Florida jurisdiction. And so you have no business in Wyoming. However, you're not doing business there. But if you set up a Florida LLC to hold that Florida property and your Wyoming LLC is now holding that Florida LLC, you can now borrow Wyoming's beneficial laws to protect your property. And that's the common misconception that people think is that they can just use any foreign LLC and just immediately get that state's protection. You have to do it in the right order and in the right way. Otherwise, you're wasting your money and your time setting it up.
Yeah. And I mean, just the most like basic advice is get an LLC in the state where the property is at. Or, I mean, we've seen people that live in Florida buy property in the Poconos in Pennsylvania. They got a Florida LLC that owns the Pennsylvania property. It's doing nothing. It's probably hurting you.
Yeah. And worse than doing nothing, they're going to have a headache maintaining it. They've got foreign registered agent fees they've got to pay. They've got to do filing reports in both states. And that becomes a nightmare to keep up with annually, in addition to the fact they're getting no extra protection. And so that's why I believe one of the reasons I got into doing this in this industry is there's so little clear information about the right way to do it that people need to at least understand if you're going to invest the time and effort, which you should, your money into protecting your properties, you need to make sure you understand what actually works.
Yeah. And we'll go through real quick, I guess, the different, let's say I'm an investor with my first, like what does the structure look like? Somebody with their first or second property compared to somebody that's got, 5, 6, 7, maybe 10.
Yeah. So I'll do a quick run through here because this is really important to understand. First of all, you get your first property. Let's say you don't really have that much net worth. You've got not a whole lot in savings, but you've scraped up enough to get your first property and maybe just put 10% down, not a whole lot of equity. I talk about good, better, and best. At a minimum, don't put this stuff in your name. The first thing you do, get commercial insurance, get the right type of insurance, make sure you're fully insured, million in premises liability, go down the list of making sure you've actually got that covered. Then you do need to transfer the property to an LLC. And you and I have talked about this a lot, and I could spend a lot of time talking about this. Know your state laws. Before you just do that transfer, you need, especially if you're doing a conventional loan, make sure you don't have a transfer tax in your state. You don't want an unexpected slap in the face like in the Poconos or in Florida where it's anywhere between 1% to 3%. You don't want to get hammered with that, not knowing you're going to have to pay that tax. But once it is in that LLC, at least it separates your ownership from the control of the asset. You no longer own it, but you control the asset. And if you bought a property in a very protective state, you really don't need anything else. For example, if you bought in Texas, if you bought in Wyoming, if you bought in Delaware, then you don't need a holding company or anything else if you just have one property in that state. But if you own in another state with very poor laws, that's when you want to start talking about what I mentioned earlier, which is a holding company. And why do we do holding companies? Because we want to protect ourselves from a lawsuit if our property is in a poor state, in a bad state in terms of laws. And if you start to grow, like you said, let's say you become a multi-state investor. Now you own properties in multiple states. There's more contingencies involved. There's more laws that you have to take into consideration. And so when you start going from one property to certainly at least two or so, I recommend using either a Wyoming or Delaware LLC as your holding company. And just to give a quick guide on how this would work, you would set up single member LLCs for each underlying property. first two properties, right? And then that single member would not be you. The single member would be your Wyoming LLC. And the way that changes is this. Now, if I sue your property in Florida and I go to the Florida Secretary of State, the Secretary of State's going to point me to Wyoming because that's the only member on that property. And when I get to Wyoming, you now have privacy. I don't know who I'm suing. You also have charging order protection, which means I can't make you sell. And this is the fundamental reason why this matters. The fundamental reason is because as an attorney that took these cases, I had to take them on contingency fee basis, which means I had to pay for all the lawsuit expenses out of my own pocket. And when you go down this road and you realize I can't force you to sell, now you're very unattractive to me. Why would I want to sue you if I can't force you to sell and I have to pay for all the lawsuit expenses? You're going to force me to go to the easy button, which is your insurance. And I'm going to be 10 times more likely to want to get an insurance settlement than try to, lose money out of my own pocket suing you individually in Wyoming. So that, or suing your LLC in Wyoming. So that works great until you get to like property 4 or 5 range. And the only deficiency, once you really start to grow and expand your portfolio, is that there's something known as the fraudulent transfer analysis with LLC holding companies. And what that means is if I've got clients with 70, 80, 90 properties, if one of those properties gets sued, all of your other properties under an LLC holding company can go into lockdown mode. They freeze. Because if you try to move or sell any assets during litigation, that's seen as a potential fraudulent transfer. So it becomes really difficult to manage that portfolio. So that's when we move to a more advanced strategy known as the limited partnership structure. We call it our paper plan, which essentially the limited partnership structure has 2 parties, right? You've got a limited partner and a general partner. And without going too in depth in this, because I know we don't have a whole lot of time on this, but one of the things you can do is here's the biggest difference. You keep your privacy, you keep your charging order protection, just like you do on the other plan. But here, if you've got lots of properties, the beautiful thing is Arizona says that if you get sued, your limited partner, which we use the trust as the limited partner, can actually sever the relationship with the general partner, which we usually use a Wyoming LLC, and take 99.5% of all of your assets and leave the lawsuit, leave the limited partnership after you've been sued. And this is really important for large portfolios because, I mean, look, if you own double-digit properties, you're probably always assessing, do I need to sell an asset? Is it underperforming? Do I need to do a 1031 exchange? You don't want to be held captive in a situation like this as you grow by only having it under a Wyoming LLC that you can't move anything around during a lawsuit. So there's levels there that you grow up to. Not everybody needs the big one. I'm going to be frank with you. What I promote is everyone has a certain risk factor they're willing to accept. Some people are willing to take on more risk than others, including for being sued. What I want to do is educate people to understand there are levels for which you can fully protect yourself. And these have been tested for the last anywhere between 30 to 50 years. These type of structures have been available under the law.
Wow. You were talking a little bit earlier about some upcoming changes to the laws for LLCs and the Corporate Transparency Act. What information have we learned so far?
So, the Corporate Transparency Act right now, for those that are, we're really looking at this at the end of 2024, leading into 2025. As it stands right now, if you have put together any LLCs at all, if you've put together LLCs, you are required to file with the FinCEN. FinCEN essentially is a financial crimes enforcement network. Portion of the federal government. You're required to be in compliance with them by January 1. The kind of caveat to that, though, is that this was actually contested in a federal district court and ruled to be unconstitutional, but then it was appealed. It was actually appealed. And so now that it's in the appellate courts, we're expecting a decision on this likely by December. And of course, here we go, the courts and federal government waiting till the very end leading up to January before they actually rule on this thing. So I'm going to tell you this, 2 big things to watch out for in 2025. The first one is watch for that. Be looking for the Corporate Transparency Act. And obviously I can provide anybody updates. I'm going to be shouting them out there as soon as I know that as soon as we find out whether or not this is going to be constitutional. If so, and you and I talked about this, it's not hard to do. You can easily be in compliance with FinCEN, but you don't want to forget. Don't forget about doing it. But if it turns out with some things that have come into place now with this potential ruling of it being unconstitutional, you also don't want to disclose information to the government if you don't have to, if they rule it to be unconstitutional. So that's number one. Watch out for the Corporate Transparency Act ruling, which I expect to happen before the end of 2024.
Mm-hmm. Yeah, and it really isn't that hard to fill out. I mean, it took me, I don't know, 5 or 6 minutes per LLC. I mean, once I figured it out, it wasn't. The interface wasn't terrible for a government website that I would expect, but
much better than I would expect it to.
Yeah, but it's just like you said, it's the forgetting thing. I mean, because people that got like your client that's got 70, 80 properties. I mean, how many LLCs do they got?
It's a nightmare. Yeah,
I have
and that's right. And the problem is, and I don't know that they're ever going to do this, but it's got some teeth to the Corporate Transparency Act. I mean, there's, $500 a day fines. There's technically prison sentences or jail time that could be associated with it. I personally think, not that my opinion matters, I think it could either be held unconstitutional, or I think the new administration that's going to be coming in 2025, one of the things they've pledged to do is to essentially eliminate a lot of that type of stuff where the government's getting interfering with that. I think there's a good chance that won't be in place. However, I don't want to be the guinea pig. I don't want to be the person where I'm not in compliance and the federal government's knocking on my door.
Yeah, we've been talking about it for a while. It's just going to have to see how that the appellate court goes, and just be prepared to file all these returns by, I think it's January 1st, right? They got to file them by? Yeah.
That's the deadline, January 1st, which is why I tell people, look into having that ready to go. That needs to be on your to-do list for the end of the year so that you don't neglect it. Obviously talk to a great CPA like yourself, or you can talk to an attorney. You can make sure that you're aware of what those obligations are going to be. But if it's ruled unconstitutional, fantastic. But if it's not, you don't want to miss that. When it's really not that difficult to be in compliance.
How many do you think are going to be filed like between Christmas and January 1st?
Oh God. Well, especially there's going to be a ridiculous amount. That's why I'm really, really hoping. I can't imagine that the appellate court is going to wait until December 15th to rule on this thing, because they're not going to do anything that late in the year. I expect that there's going to be a decision by December 1st is my expectation, that they're going to let us know what that result is. If they don't, I'm telling a lot of my clients, hey, if we start getting into December, it probably just need to be in compliance. Don't push this to the very end. And if it's ruled unconstitutional, that information can't be shared with attorneys or anyone else anyway. If you actually read the statute, if you actually read the regulations, there's actual penalties. Now, whether the penalties will actually would be enforced against the government, but there's penalties for sharing that information with anyone other than either information from a financial institution for criminal purposes, criminal investigations, or something that the government is sharing amongst itself, its own internal sources. So, I'm not that concerned about it. I just don't want people to miss it. And then FinCEN's obviously taking it to another level where they're actually going to want to start trying to regulate all financial transactions with conventional loans starting in December of 2025. And so it's kind of like you're starting to see that the clamps coming down, where the government's trying to say, I want to know who you are, what you're selling, who you sold it to, how you're running it. And they're starting to look at that for conventional loans because they think there's fraud involved.
Yeah. So, well, I mean, the CTA, I mean, everything, they mean well with it. They're trying to prevent against money launderers and thieves and people that start up a business and go steal a bunch of money from people. These bad contractors that steal a bunch of money from people. They're trying to go after people. But at the same time, it's also putting a huge burden on the small business person in America.
Yeah, it's like anything else, right? The government always means well, but unfortunately, it can tend to affect all the innocent actors, where it puts more of a requirement on all of us to be in compliance. You're right.
Talk more about the residential loan thing, because this is the first I'm hearing about this.
So it's similar. It's similar to the Corporate Transparency Act, but now it's going to require businesses to report their. It's actually going to report entities that acquire real estate. Now, this is kind of strange. So same government regulation, FinCEN, right? Financial Crimes Enforcement Network. And instead of this being necessarily a specific law, these are regulations that have been drafted that have already been approved by FinCEN, where they're saying we're now going to require this. So that what this means is that transfers involving LLCs, trusts, and other entities may have to detail specific information when they do a purchase of a property, but it has to be a conventional loan. Okay. So commercial loans, they're not as concerned about, but they're much more concerned about conventional loans. And so this even applies to trusts. You remember back in the good old days when I would always talk about how you use a land trust to create privacy. You can still do that, but if you don't set up your land trust the right way now to create that privacy, you'll now fall under these new regulations unless the new Trump administration comes in and says, we're not going to have this. So I'm not bringing this up right now to create panic or scare people, but what I want them to understand is this is something that's already on the books, that unless there's a change to it, a year from now, you're going to have to start preparing for the fact that purchases in LLCs, transfers into LLCs of properties with conventional loans, which is the most popular thing that short-term rental owners do, you're now going to have an additional layer of compliance that you're going to have to report that information to the federal government.
So a transfer from personal to LLC, that used to be pretty much between you and the Secretary of State and maybe the bank. Now it gets reported to the federal government. That and why is that? Do they suppose people are buying properties in their personal name and putting for other people and transferring it? Or
so this is really good. This goes back to the same spirit of the law for the Corporate Transparency Act, which is, what are they trying to stop? They're trying to stop money laundering, terrorist activities. They're trying to stop illicit activities in the background. So the federal government believes that, and there has been some substance to this, where there have been scammers that were involved where they would take someone else's money and buy lots of real estate, rental real estate, and turn around and basically pad their own pockets by funneling illicitly gained money into what looks like, legal purchases of rental real estate. So what they want to do now is to be able to properly connect the dots. If they can find out that someone obtained this money illegally, they want to connect it to every rental property that someone would have purchased to try to launder it out of the public eye. And so that's what the spirit of this is. But it's going to be a huge pain for rental properties, for investors, if this goes into effect, unless you use some strategies here to avoid that, which you can still use the land trust. It just, if you DIY it and you don't set it up right, you can end up having some problems. You'll still have to comply with the federal government because trusts are included.
And so that part of the residential loan, that's already been voted on. It's going to happen, or they're still.
So these are regulations that are tied in. I think this emboldened FinCEN, the Financial Crimes Enforcement Network, to say, we got the Corporate Transparency Act. We're going to track all this other stuff. We need to also track. So you know how the federal government works, right? Once a law goes into effect, then what they do is they just, instead of passing a new law, they just create additional federal regulations that show how they're going to enforce it. They see this as nothing more than a further enforcement mechanism from what happened under the Corporate Transparency Act.
Right. I see. Wow. Something to look out for.
For sure. I'm hoping it doesn't make it to December of 2025.
Anything else before we head out?
No, I just encourage people, look, be aware of these things that are coming up. And we didn't talk much about insurance. And the big thing is there is so much, there's a lack of clarity with people understanding what type of insurance they have. The last thing I'm going to say is this: everybody listening right now, you should go check your policy. When I learned from insurance companies themselves that 67% of short-term rental investors do not have commercial coverage and they don't know it, you need to make sure you have the right type of insurance and that you're properly not underinsured. You need to make sure you've got enough of that insurance. And so that's the big thing right now. Even if people think they don't need LLCs, they don't need asset protection, you cannot just be sitting out there bare with no strong commercial insurance, because otherwise it's not a matter of if, it's a matter of when someone's going to get hurt on your property.
Awesome. Where can listeners of the podcast find you?
Yeah. So any questions that anybody might have, or if you decide you would like to get something put together custom to see what your asset protection needs might be for your properties, you can reach out to me personally at jeff@strlawguys.com, or you can reach out to our website, strlawguys.com. And we've got some free resources. And if you look up STR Law Guys on YouTube, I've got a bunch of free videos that you can check out for further education on that. But I'm happy to answer any of those questions.
Awesome. Thank you so much.